The first case to come before us today is State versus Thomas, and the state of Ohio has waived their oral argument time, so the appellant may have 15 minutes to proceed. Thank you.
May it please the court, good morning. I'm John Parker. I do represent Mr. Thomas. Appreciate the opportunity to once again argue this case before the court. On behalf of Mr. Thomas, I think it's important to have a general principle in mind when thinking about this case, and that's the principle of self-defense. And as Blackstone said in his commentaries many years ago, citing Jewish, Greek, and Roman law, if a person kills an attacker, then the slayer is in no kind of fault whatsoever, not even the minutest degree, and is to be totally acquitted and discharged with commendation rather than blame. And this was fundamentally a self-defense case. Mr. Thomas testified at his trial. He was originally charged with aggravated murder. He was convicted of straight murder with a firearm, and he testified in his counsel in closing argument, argued self-defense, and the court instructed on self-defense. However, one of the assignments of error that we raised was at the very beginning of the case, an opening statement, in fact. Counsel did not even mention self-defense. In fact, if you look at the very short opening statement, pages 312 to 318 of the transcript, on page 318, defense counsel says, "Ladies and gentlemen, you must evaluate this evidence and ask why." But the defense counsel never told them that this was self-defense.
Well, but he did in his opening statement mention something about, I'm not saying it was the best necessarily, but he did mention that that your client was not the initial aggressor, which is one of the tests you look at in regard to self-defense.
Well,
so it was hinted at the very least.
At the very best, it was hinted at. What it was really concerning was the difference between prior calculation and design and an eruption of events, the difference between aggravated murder and murder. And what is interesting is that the jury went along with the murder conviction rather than aggravated murder, showing the importance of opening statement. But in Ohio, self-defense is an affirmative defense. The burden is on the defense to put on evidence, to prove by a preponderance of the evidence this affirmative defense, and counsel completely omitted that from opening statement. And that's
so what's the significance of omitting it from opening statement where you go on to offer proof to support the affirmative defense?
Well, I think it diminishes the testimony that you do offer in support of self-defense. You know, the jury must have been quite surprised when Mr. Thomas got up on the stand and testified as to self-defense when they were not forewarned about this in opening statement whatsoever. It's not reasonable in our position to omit an affirmative defense that the defense has to prove. And that's what happened here. And if you look at the jury questions posed once the case was submitted to them, I think it reflects a misunderstanding or at least some confusion over what is self-defense. And let's look at the jury questions. The jury question number 3 that was submitted wanted to know what the at-fault jury instruction meant. They said, what if the defendant was 10% at fault and agreeing to the fist fight when the victim produced a firearm?
And I know there's all kinds of issues in regard to this jury question and so forth. And I think maybe some of the problem, though, is that there's nothing on the record about any of this, right?
The only thing on the record about the jury questions are the written questions submitted by the jury and the written answers given by the judge. There was no discussion on the transcript with the judge and the attorneys or any of that. It's simply in the court file. There are 3 written questions, as I recall, from the jury, and the judge gave written responses. But clearly the jury was struggling with this issue of self-defense. So there was also a problem with the duty to retreat instruction, which is a fundamental concept in Ohio law. And that is that there's only a duty to retreat when someone can do so in complete safety. And the only testimony concerning the struggle, the self-defense issue, was through Mr. Thomas. He testified that there was a fist fight. He agreed to a fist fight. He gets out of his car, and the victim is rushing at him. Mr. Thomas takes the first swing, misses. The victim produces a firearm, unexpectedly.
So what jury instruction should have been given? Because another problem is, I don't know that anybody requested a jury instruction in regard to maybe the initial aggressor. Well, I know that duty to retreat you have a problem with, but I mean, what jury instructions are you submitting that should have been done to clarify the issues for the
Well,
jury?
I think there was no objection to the instructions given. That's in the record. I mean, it's clear from the record. So it's a plain error, ineffective assistance of counsel argument. There should have been no duty to retreat instruction under the Casano and Marbury cases that I cite in my brief because Mr. Thomas could not escape in complete safety. I mean, as he testified to, if the victim got a hold of the gun, once the victim produced the gun, Mr. Thomas testified he was able to knock it out of his hand, and then there was a struggle for the gun, and Mr. Thomas got it and shot 3 times. There was an independent witness who heard 3 shots quickly, 3 quick shots, which is important, who heard 3 quick shots and then looked out a window and saw what was there, but she did not see what happened beforehand. But the only evidence is that Mr. Thomas was able to get the gun away and had to shoot in self-defense because the victim kept coming at him, was his testimony. So he had no choice. As he testified, if the victim got a hold of that gun, he was going to be dead.
Okay, so you're saying there shouldn't have been a duty to retreat or
That's
instruction.
correct.
What else?
With the at-fault instruction, it's our position that the instruction given by the court was so vague, and the jury question reflects how vague it was because they didn't understand it. They said if he's 10% at fault, what do we do then, basically? And as you know, under Ohio law, the defense must prove the various elements of self-defense by a preponderance.
So what should the judge have done?
The judge should have answered, the judge should have clarified what preponderance of the evidence meant, and that if they find that he was only 10% at fault, then necessarily he's proven by 90%, arguably, certainly by a preponderance of the evidence, that he wasn't at fault. So he's met his burden there.
Part of the challenge that I think we have in reviewing this case is that, and my colleague is asking you questions about what should have been, what the court should have done, is that we weren't really advised of that in the appellate brief, what should have happened. And so, it seems like we're in a position of kind of making the argument. You understand what I'm saying?
I understand your question. I apologize if I wasn't clear in my brief, but I think what I was attempting to say is that defense counsel had a duty to object to these improper instructions, and that it was plain error for the court to give the instructions based upon the case law and the questions posed, quite frankly, and that the judge had a duty to, it's ultimately the trial court's duty to give proper jury instructions. Defense counsel has an obligation, obviously, to object to improper instructions, and they failed to do that
But
here.
OJI doesn't define at fault.
OJI is simply a guide, it's not the law. And I know courts are most comfortable going with whatever's in OJI, trial judges especially seem most comfortable with using. And I think what I argued was the at-fault instruction under this peculiar fact pattern, it is the problem. And this is a somewhat peculiar fact pattern, and OJI is not going to cover every fact pattern.
Well, in looking at OJI, I am shocked that there's no definitive, redundant definition in regard to at fault. But there is case law that defines what at fault means. So it seems like you say it's the judge's ultimate responsibility, and I agree, but at the same rate, the attorneys are there to assist.
Absolutely, and they didn't do that here.
But you still have to demonstrate prejudice.
Well, and the prejudice is that where the jury says, what if he's 10% at fault? I mean, in essence, what they're saying is that if, that he's 90% not at fault, at least that's a reasonable interpretation. And if he's 90% not at fault or only 10% at fault, then he's met his burden. And the jury should be instructed as such. Perhaps they didn't understand what preponderance meant. Certainly the defense counsel didn't explain this in opening statement, didn't tell them from the very beginning what they were expected to do. And that's
Do you
part of the
think this
problem.
is an issue of initial and primary aggressor or an issue of mutual combatants?
I think it started off as an agreed fist fight, and the victim escalated it by producing a firearm. I mean, that's what happened here factually, was that these two men agreed to a fist fight. My client arrives at the location, gets out of his car with the victim charging at him, and then he produces a firearm. That's not what he agreed to, and it's a much different situation. Moving on to a couple of other issues I really think the court needs to consider. One of those issues are concerning the so-called rumor hearings, where there was a juror that brought to the court's attention that she knew one of the witnesses. And the court quite properly had a hearing, and the juror said, it's not going to influence me in any way, and that's fine. Everything was done properly there. But what wasn't done properly is that juror mentioned that she told the other jurors that she knew this witness. So we don't know what influence her comments had on the other jurors. And the judge should have had the same type of questioning with the other jurors that he had with this one particular juror. And secondly, the judge put on the record that he had a complaint from a juror, we don't know who, had a complaint from a juror that the jury could hear audible responses from the gallery during the trial. And we don't know what they heard exactly, we don't know what influence, if any, those audible responses from the gallery had upon the jury, and the judge should have had a Rimmer-type hearing or a Rimmer hearing to determine whether it had any influence on the jury or not. And the law is pretty clear that there is a presumption that the jury was prejudiced by this outside influence, so to speak. And so it's our position that the judge should have had hearings in addition to the one he had, and defense counsel should have asked for these hearings. Defense counsel was ineffective when he did not, and it was plain error otherwise.
Well, Mr. Parker, I think that, we've all tried cases, and you want them all to be perfect, but they can't be. And so when you get to a situation where you've got, especially a situation here where someone has been shot, there are going to be tensions in the courtroom. If the judge stops every time someone raises the fact that they heard noise or saw someone rolling their eyes or gesture and had a Rimmer hearing for everything, you'd never get through the trial. So there is this notion of the court having discretion. Would you agree?
I do not agree that the court has discretion once it's brought to the court's attention that the jury has been somehow influenced or affected potentially by some outside influence. I do not think the court has discretion in that situation. And what I'm complaining of is not just, yes, the courtroom evidently was very tense because this was a homicide and both families were there, and it was an emotional, as is not unusual, it was an emotional situation. But here we had the judge put on the record that a juror complained to the judge about what was going on. So what did that complaint consist of? Well, how was that juror and potentially other jurors? Was that juror speaking for himself and herself only, or was that juror speaking for everyone on the jury? That somehow they were being influenced by what was going on in the courtroom. I don't know which side of the family it was, if it was one side or the other, or both, or somebody totally unrelated to either family. But that's why you have a hearing, because a fundamental principle is that jurors are not to be influenced by anything outside of what they hear from the witness stand and the evidence they receive. And so the law is very clear, Your Honor, in my view, that once there is some indication that a juror has been influenced, a Rimmer hearing is required. It's not discretionary. And here you have a juror in the first instance testifying, bringing it to the judge's attention, as she should have, and there was a proper hearing. It didn't take but a minute. You know, it was a very short hearing, as these usually are. But the judge didn't follow up on that in the first instance with the other jurors, and then perhaps more importantly, but equally important, is this juror complaining about what is going on in the courtroom, and that at least that juror, if not the entire jury panel, can hear what's going on. And it's no discretion to have a hearing under those circumstances, I would suggest.
Mr. Parker, your time is up.
Thank you very much, Your Honors. I appreciate the attention, and we ask that you reverse and grant Mr. Thomas a new trial.
Thank you. We will take the matter under advisement and issue a written opinion that will be sent to you as well as to the state, and you can look also on our website, the Supreme Court website for the case. Thank you.
Thank you very much.